So let's talk about what a premise liability case is. It is a case where someone has been injured on the property owned by another person or entity. When that happens, the laws of Ohio says that the property owner may be responsible for your injuries. The reason these cases are serious is if someone has been seriously injured, you need to determine by hiring a lawyer to figure out whether or not the property owner is responsible for those serious injuries. A premise liability case can fall into several categories. One of them is someone is injured as a result of falling or slipping on someone's property. We typically see those cases in grocery stores or convenience stores, something where you're falling or slipping on the ground. You also have cases involving falls outside of a parking lot or sidewalk owned by a property owner. So that's one type of category. The other category that we see a lot is cases involving negligent security. And what that means is someone is injured through the actions of a third party, the criminal actions of a third party. And in this negligent security case, what you're looking at is whether or not the property owner had adequate security measures in place to ensure the safety of his patrons, customers, and invitees. And so when someone is unfortunately raped on a premise, sexually assaulted, aggravated assault, shot, stabbed, or some type of physical injury due to the actions of another person, you need to hire a lawyer. You need to hire the Cochran firm to make sure that the property owner did not have a duty to you to provide security and security measures that would have prevented that act. Depending on which type of premise case, but just like most cases in Ohio involving personal injury, you have to show that the potential defendant had a duty, that duty was breached, and as a result of that breach of duty, you were caused harm or injury. In a premise case, if it's a slip and fall case, you have to show that the property owner had a duty to make sure you didn't fall. They breached that duty, and because they breached that duty, it caused you injury. In a negligent security case, you're looking at the same things, but you're looking at the fact that a property owner has a duty to provide security measures or a security guard because the property owner is aware of criminal activity occurring on their property. And when that property owner knows that it's a dangerous location or that crime occurs on that property before your incident, the duty is created by the fact that they're on notice that crime is foreseeable in this area. Now, once they have that notice, they have that duty. If they don't provide the extra security or extra security measures, then they are responsible for your injuries. This happens in hotels where people can get assaulted, raped, shot, in parking lots. It happens at gas stations, nightclubs. So whenever you're at another premise, remember that property owner has a duty and responsibility, if they're on notice of a danger or a hazard, to protect you. And when that happens and they fail to protect you, you need to call the Cochran firm. The great thing about the Cochran firm is that we have the reputation as well as the results in premise cases. We have several $1 million verdicts, several $1 million settlements. We all have experience at the Cochran firm in working these cases. We know the experts in the field to help us prove our cases. And so we're not just another firm that you call, that you see on TV telling you to call them. We're actually trial litigators. We're trial lawyers. We have been tried and tested in this area of premise liability, and we know what areas of responsibility and duty that these property owners have. And so when you call us, you're calling experts in this field. We understand what it's going to take to prove your case and get it ready for trial, or get it ready to try to settle your case if that's what is needed. But whatever happens in your case, we are well equipped and prepared to do it. Cases, whether it's premise cases, medical malpractice cases, motor vehicle accidents cases, it all depends on the facts of the case. But one thing at the Cochran firm is, when we get your case, we immediately start working from the day we are retained. We have investigators that are ready to go. We're sending out requests to the other side to let them know, to preserve the evidence, to put them on notice that we believe that you have a claim against them. And if everything is done quickly and we're retained quickly, we can immediately start the work. And these cases can be resolved within a few weeks, or it can take a couple of years. But whatever the timeline is, we are working diligently every day to get you closer to the justice that you deserve. Whenever you're injured at someone else's property, at an apartment complex, at a shopping center, at a nightclub, it's important you call us first, immediately. The reason is we can immediately start investigating what happened to you. But it's also important because under Ohio, you only have 2 years to bring a claim from the date of the incident. That 2 years can go back quickly. And a lot of people don't think, man, do I have a case? Should I call a lawyer? If you're injured, you should call the Cochran firm so that we can investigate to let you know whether you have a viable claim. But we can't do that until we're called. And remember, you only have 2 years to bring a claim. So call us immediately so we can get you the justice you deserve.